The doctrine of separation of powers between the states and the federal government in the USA. Introduction. No feature of the American government, national states and often local, is more characteristic than the separation of powers combined with precautionary checks and balances. Professor Og. American Constitution is based on the principle of separation of power, the idea that three organs of the government should be kept distinct and independent, each acting as a check on the other. This is the most important feature of the American system. Meaning according to Black's Law Dictionary. Separation of powers in the division of governmental authority into three branches of government, that is, legislative, executive and judicial, each with specified duties on which neither of the other branches can encroach, intrude, invade or trespass. Origin and need for the theory. Since the ancient days of Aristotle, political writers have recognized the threefold distribution of governmental functions of power: executive, legislature and judiciary. Each power is exercised by its own department of government. Montesquieu, the French thinker of the 18th century, was the first writer who expounded this division as a theory of separation of powers to safeguard the liberty of the individual. A. Montesquieu's exposition. He explained his theory in these words: in every government, there are three sorts of power: legislative, executive and judicial. The liberty of individuals requires that neither all this power nor any two of them should be placed in the hands of one man nor one body of men. B. James Madison's view of the Montesquieu theory. According to him, Montesquieuan theory meant only that there could be no liberty if the whole power of one department is exercised by the same hands that possess the whole power of another department. Theory of separation of power in America. A. Implied doctrine. The U.S. Constitution does not explicitly proclaim the principle of separation of power. It is made impliedly in the Constitution and can easily infer from the way it is drafted. 1. Article I, Section 1 of the Constitution declares, all legislative powers herein granted shall be vested in a Congress of the United States. 2. Article 2, Section 1 begins with, the executive power shall be vested in the President of the United States of America. 3. Article 3, Section I declared, the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain establish. B. Doctrine in practice. In the USA, a serious and deliberate attempt was made to apply the theory in practice. The American chief executive, the president, is elected by the people for a period of 4 years. He cannot initiate legislation. He is independent of legislation as it is independent of him. The judges are independent of the executive and the legislature. Check and balance system. The framers of the Constitution believed that to grant unchecked power to any person is sure to invite oppression, domination, coercion, and tyranny. Hence the separation of power will not be enough remedy against abuse of power. Power must be checked by power. So they devised a system of checks and balances. Effective separation of power. The separation of power has created a new system of government, called the presidential system, which is quite different from the parliamentary system of Great Britain. It also introduces the doctrine of judicial review. Alternation of doctrine of separation of power. The constitutional doctrine of separation of power has been altered by the emergence of A. the political parties, B. the presidential leadership in the legislative proposal, and C. by the growth of delegated legislation. Criticism on doctrine. The doctrine of separation of powers has been criticized on the following grounds. A. Complex system. Separation of power has made the structure more complicated. B. Frustration. The doctrine of separation of power has created frustration among the three organs of the government. C. Loose coordination. It makes the government institution to be loosely coordinated. D. Mutual rivalries. It has created mutual rivalries among all three branches of government. Conclusion. The theory of separation of powers makes the governmental organ work independently of the other, but the framers of the Constitution knew that an absolute separation would make government impracticable. So they also devised a system of checks and balances which compel them to work interdependently.